Please be seated.
The case before the court is a case concerning certain activities within the Malachi Gap. The parties are applicant Amalia versus respondent, the Republic of Britannia. The applicant and the respondent are each allocated 45 minutes to present their case.
Good afternoon. The court sits this afternoon to hear the oral arguments in the case just named, filed by the State of Amalia against the Republic of Britannia. I will now call upon the agent of the State of Amalia to present your oral arguments. Excellency.
Madam President, Your Excellencies, my name is Emily Chalk, and I appear with my co-agent, Camille Boileau, for the applicant, the State of Amalia, in this case. I will speak for 22 minutes, my co-agent will speak for 20 minutes, and we will allocate 3 minutes for rebuttal. There are 4 issues in this case. First, can Britannia authorise the construction of an artificial island without considering its effect on a certain fish species critical to Amalia, and then disclaim liability to compensate Amalia when that construction considerably reduces that fish population? Second, can Britannia challenge ownership of artefacts that Amalia lawfully acquired centuries ago, and then deploy naval patrol vessels to support that claim? Third, can Britannia challenge Amalia's pursuit of a yacht which had come into its contiguous zone and was suspected of human trafficking? And fourth, can Britannia claim jurisdiction over the deaths of Amalian nationals that occurred on an Amalian ship in contravention of Amalian law, and then insist that having prosecuted and convicted him, Amalia must now return the culprit to Britannia? I will make submissions on the first and second of those issues. My co-agent will make submissions on the third and fourth of those issues. My first submission is that Britannia's authorisation of the construction of Excelsior Island contravened its international law obligations, and consequently, Britannia is liable to compensate Amalia for the economic consequences caused by that construction. This submission is contained on pages 1 to 14 of Amalia's memorials. The first and most critical pleading that we make here is that Britannia's authorisation of the construction of Excelsior Island contravened its obligation in customary international law to act with due diligence. In the 1949 Corfu Channel case, the 1996 Nuclear Weapons Advisory Opinion, and the 2010 Pulp Mills case, the International Court of Justice has confirmed that in customary international law, states have an obligation to act with due diligence concerning activities within their jurisdiction or control, if those activities have a likelihood of causing reasonably foreseeable and significant harm to the environments of other states or environments beyond that state's control. Articles 1 and 2 of the draft articles on the prevention of transboundary harm clarify that what constitutes reasonably foreseeable damage in any case is contingent both on the magnitude of a possible harm and the probability of that harm occurring, and what constitutes significant damage is more than minor or detectable, but less than serious or substantial. Those articles also indicate that those assessments are to be made at the date of decision making. In this case, in the compromis at paragraphs 19, 20 and 25, as well as in the clarifications at paragraph 2, the facts indicate that the construction of Excelsior Island required dredging 2 billion cubic metres of oceanic sand and rock entirely from within the Malachi Gap. Prominent marine scientists had predicted that any major dredging activity in the gap could cause catastrophic consequences for native species, and that any underwater landslides, if those eventuated, could cause particularly grave damage, and the dredging was to occur close to the only known breeding ground of the Dorian wrasse. Collectively, in our submission, those facts meant that both harm to the Malachi Gap generally and to the Dorian wrasse specifically was reasonably foreseeable and significant. And that's important because in the pulp mills case that I cited previously, at paragraph 204, the court confirmed that in those types of cases, states have an obligation to conduct an environmental impact assessment. The court said at paragraph 205 that it is for each state to determine in its national legislation or in the domestic authorization process for that project the specific content of the environmental impact assessment required in each case. However, there are two restrictions on a state's entitlement to decide what its environmental impact assessments should contain. First, as the court continued at paragraph 205, that determination must be made having regard to the nature and magnitude of the proposed development and its likely adverse impact on the environment. Second, as the commentaries to Article 7 of the draft articles on the prevention of transboundary harm state at paragraph 8, the assessment should include the effects of the activity not only on persons and property, but also on the environment of other states. And in this case, as to that first restriction, the nature and the magnitude of the construction of Excelsior Island, the largest dredging project ever conducted, and its predicted adverse impact on the environment of the Malachi Gap necessitated that an environmental impact assessment consider the effect of the dredging on the Malachi Gap. As to that second restriction, the environmental impact assessment had to consider the effect of this construction not just on Britannia's environment, but also on Amalia's. Britannia breached its obligation to act with due diligence because Britannia failed, and this is stated incredibly explicitly in the compromise, the final sentence of paragraph 23. It failed to require the environmental impact assessment to take into account the effect of the dredging on the waters or the fish species of the Malachi Gap. Further, in response to the contention contained in Britannia's memorials at page 3, that Britannia's possession of both Excelsior Island Gas and Power's environmental impact assessment and the International League for Sustainable Aquaculture's report were sufficient to enable Britannia to make an informed assessment, the compromise at paragraph, subsequently in the paragraphs, indicates that Britannia's ambassador was in possession of that report, yes, but did not convey that report to Britannia's Department of Resource Management. So that is the first breach of international law in this case. But there's also a second.
Before you go any further, you seem to rely on the concept of due diligence, and I wonder, what do you mean by due diligence? What are the legal elements or yardsticks of due diligence which can become the basis of what you might consider to be either a lawful or an unlawful act under existing international law?
Your Excellency, there's been very little jurisprudence to assist in the answer to that particular question. The court has been reluctant to elaborate on exactly what due diligence might require because it is so case specific. However, in the 2011 advisory opinion of the Seabed Disputes Chamber of the International Tribunal for the Law of the Sea, the court did give some guidance as to what that yardstick of due diligence might mean. And it said, in that particular case, the facts were concerning the exploration of polymetallic modules in the Pacific Ocean. The court said that exploitation would require a higher standard of due diligence than exploration, because exploitation is more dangerous and has more significant consequences than exploration.
Are you claiming that this decision of the Law of the Sea Tribunal constitutes customary international law on which this court should rely upon?
No, Your Excellency. The source of the importance of that particular case is rather Article 38(1)(d) of this court statute as a subsidiary source for determining what due diligence might mean, and that's because it's a judicial decision, not because it's an example of state practice. So I said...
I have a question too for you. What are the minimum requirements for a satisfactory environmental impact assessment under international law?
The two that I mentioned previously, Your Excellency. First, that the environmental impact assessment takes into account the nature and magnitude of the proposed development, and second, that it considers the impact of the activity on the environment of other states.
It is supported by some decided cases of the International Court of Justice?
Your Excellency, there's been very little jurisprudence on this particular topic beyond the pulp mills case and the Gabshikovo-Nagimaros case, and the court in those particular cases hasn't specified exactly what the minimum content of an environmental impact assessment would be, only what a state has to take into account when it's making its decision about what that content should be.
Thank you, Ms. Chalk. I think you'd better get on to the second ground.
Thank you, Madam President. The second breach of international law in relation to the construction of Excelsior Island goes to the Malachi Gap Treaty. Article 12(d) of the Malachi Gap Treaty requires the parties to cooperate with each other, and I'm quoting here, in relation to the exercise of their respective rights, giving due regard to each party's unique interests in the Malachi Gap. The Malachi Gap Treaty, however, does not define cooperation, nor does it define due regard. Article 31(1) of the Vienna Convention on the Law of Treaties stipulates that a treaty is to be interpreted in accordance with the ordinary meaning to be given to the terms of that treaty in their context, as well as with consideration of the object and purpose of that treaty. In response to the assertion contained in Rotania's memorials at page 6 that cooperation only requires that states act in good faith and contemplate changing their position during those negotiations, I would refer the court to the 1974 fisheries jurisdiction case between the United Kingdom and Iceland. And in that particular case, which is comparable because it also concerned transboundary fisheries resources, the court held at paragraph 69 that cooperation requires states to negotiate so as to reconcile their interests so that they can coexist, taking into account the comparative dependence of either state on the fisheries, as well as the need to conserve natural resources. And in this particular case, Amalia was highly dependent, both on fishing generally and on the Dorian wrasse specifically, and we know from the compromise that Rotania was not. However, Rotania failed to take the International League for Sustainable Aquaculture report into account in its development approval process, and as I indicated previously, it approved an environmental impact assessment that didn't even take into account the effect of the dredging on Amalia's interests. That was the preservation and protection of the Dorian wrasse. Unless I can be of further assistance to the court on this point, in the interests of time, I will move to my second substantive submission. And this deals with quite a different issue, Your Excellencies. It goes to the issue of the Kargast, and more specifically to the artefacts contained on the Kargast. Our submission is that Amalia owned the artefacts recovered from the Kargast and was entitled to authorise their salvage, and consequently, Rotania's deployment of naval patrol vessels to the wreck site of the Kargast contravened international law. That submission is contained on pages 14 to 24 of Amalia's memorials. The first and most critical issue here requires the court to determine which of these states is the owner of the artefacts. In the 1928 award of Island of Palmas, arbitrator Max Huber confirmed at page 14 that a juridical fact must be appreciated in the light of the law contemporary with it, and not of the law in force at the time when a dispute in regards to it arises or falls to be settled. So in order to ascertain the owner of the artefacts in this case, the court should apply the law in effect at the time that these artefacts were seized in 1510. The contemporary jurists of that period, Hugo Grotius, Balthazar de Ayala, and Dalveer Gentili, all writing between 1582 and 1625, but about this period, as summarised by the late Sir Ian Brownlee, state that at the time there were two conditions for booty seized by a belligerent in warfare becoming the property of the seizor state. First, there had to be an authorisation of hostilities by the sovereign, and second, those hostilities had to be conducted for a just cause. As to the first requirement of an authorisation of hostilities, at the time, the common practice of states was to issue letters of marque not in the medieval fashion during peacetime to a single individual as a measure of reprisal, but instead during war as a means of augmenting the issuing state's naval capacity at short notice, because at that time states did not have standing navies. And for that reason, states at the time considered the issuance of a letter of marque to be tantamount to a declaration of war. The jurist Honoré Bonnet, writing circa 1382 to 1387, in fact concluded that reprisals and letters of marque themselves constituted a kind of war. And that's important because...
Counsel, don't you think that these arguments of the 13th and 15th centuries are somewhat dépassé by what the law of armed conflict and use ad bellum and use in bello are all about these days?
Certainly, Your Excellency, and the way that Amalia acted in the 1500s would be absolutely unlawful by the kind of standards that you mentioned by today's law. However, Amalia acted in accordance with what the law was in the 1500s, as different as it was during that period. And the reason that all of the facts that I was mentioning are the jurists that I was mentioning previously are relevant is because in this case, compromis paragraph 32, the facts indicate that Baldric Verdigris held a letter of marque from the King of Amalia when he sacked Helios. As to the second requirement of a just cause, Sir Ian Brownlee summarises the work of jurists including Niccolo Machiavelli, Alberico Gentili, and Hugo Grotius, all writing between 1513 and 1625, but again about this period, and concludes that the contemporaneous position was that, and I quote, "a war might be just on both sides. In substance, therefore, the doctrine of just war was deprived of any limiting effect." Therefore, because Baldric Verdigris held authorisation from the King of Amalia to commit hostilities when he sacked Helios, and because the requirement of just cause didn't have a limiting effect at the time, property in these artefacts passed from Britannia, who was undoubtedly their original owner and does continue to have a cultural interest in these objects, to Amalia in 1510. That is also why Amalia, as the owner of these artefacts, and undoubtedly the owner of the Cargast itself, was entitled to authorise their salvage. In the interest of time, I'll now turn to my final submission. And this deals with the deployment of naval patrol vessels to the wreck of the Cargast. In our submission, Britannia's actions did not constitute valid law enforcement measures. In the 2007 decision of Guyana and Suriname, which we accept is factually more serious than this particular case, the Permanent Court of Arbitration held at paragraph 445 that to be lawful, any force used in law enforcement activities must be three things. It has to be unavoidable, has to be reasonable, and it has to be necessary. In this case, Britannia's deployment of naval patrol vessels to the wreck of the Cargast was not unavoidable, wasn't reasonable, and it wasn't necessary, because Britannia did not offer to negotiate about whether these objects should be salvaged, how that salvage was to occur, or what should happen after these objects had been salvaged. And that leads us to Article 2.4 of the United Nations Charter, which is exceptionally clear. It requires states to refrain both from the actual use of force and from the threat of the use of force. In the compromise, paragraph 35, Britannia's Minister for Cultural Affairs states that Britannia will not tolerate the presence of so-called looters close to the Kargast and reserves the right to deploy naval patrol vessels to prevent what she calls the desecration of Britannia's national heritage. And Britannia did more than simply make that statement. It exercised the right that it had asserted. In the clarifications at paragraph 8, the facts are also consistent with the interpretation that once Britannia deployed naval patrol vessels to the wreck of the Kargast, Lesley seized his salvage. Further, in response to the assertion contained in Britannia's memorials at page 18 that the deployment and statements were a valid countermeasure to a possible use or threat of force, Article 50, paragraph 1 of the Articles on State Responsibility states explicitly that countermeasures shall not affect the obligation to refrain from the threat or use of force as embodied in the Charter of the United Nations. That is, it stipulates that forcible countermeasures are not acceptable in the context of the threat or use of force. That is why Britannia violated the prohibition on the threat of force, and it can't rely on countermeasures as a defence. In conclusion, Madam President, Your Excellencies, Britannia's submissions are characterised by an inherent tension, by their insistence that the artefacts recovered from the Kargast were so culturally significant to Britannia that their protection required the deployment of naval patrol vessels to the wreck of the Kargast, and yet their maintenance, that the Dorian Ras in the Malachi Gap were of so little importance to Amalia that Britannia could authorise a project which was predicted to cause considerable harm to the Dorian Ras without even taking them into account. Unless I can be of further assistance, Your Excellencies, that concludes my submissions.
Thank you, Ms. Chalk. I'm glad you didn't ask for an extra minute in view of the questions that took up part of the time. Are you going to continue the case? Is your colleague going to continue the case? Ms. Bellew, please.
Madam President, Your Excellencies, I will be making two submissions. First, concerning Amalia's exercise of enforcement jurisdiction, it is our submission that Amalia's pursuit and arrest of Luz complied with international law. And second, concerning Amalia's exercise of adjudicative jurisdiction, it is our submission that Amalia had jurisdiction to try and prosecute Luz in respect of the Rose Hill incident, and accordingly that Amalia is under no obligation to return Luz to Britannia. I'll turn now to the first of these points concerning enforcement jurisdiction, and here Amalia justifies its pursuit and arrest of Luz on the basis of the right of hot pursuit, and the right of hot pursuit is contained within Article 23 of the High Seas Convention, to which both states are parties, and it's replicated within Article 111 of the 1982 United Nations Convention on the Law of the Sea, and is taken to represent customary international law. Now, Your Excellencies, there are 5 conditions required for the lawful exercise of the right of hot pursuit, and these are cumulative. We have set these out at page 24 of our written memorials, but for the purposes of my oral submissions, I will be addressing the 2 most contentious aspects of the pursuit. And the 2 most contentious aspects are, first, whether Amalia had good reason to believe that there had been a violation of the rights for the protection of which the contiguous zone was established, and second, whether a radio transmission constitutes a lawful signal to stop. Now, turning to that first issue concerning the good reason to believe requirement, and the first aspect that is in dispute between the parties, and it concerns the type of control that can be exercised by a state within its contiguous zone and whether that type of control encompasses hot pursuit. So there is an argument put against us, Your Excellencies. This can be found at page 21 to 22 of the respondents' memorials. The argument put against us to the effect that hot pursuit cannot be commenced from the contiguous zone in respect of a suspected violation of customs, fiscal, sanitary and immigration laws within that zone, but rather that Amalia had to wait until the Daedalus passed through its contiguous zone, entered its territorial sea, was there suspected of committing a violation of one of those 4 types of laws, exited back out into the contiguous zone, from which point pursuit could be commenced. And in our submission, that interpretation ought to be rejected. The first reason that we submit that is if we look to the practice of states, it's simply not consistent with that position. Professor O'Connell has summarised the practice of states, and he states that the current of opinion and practice is against that narrow technical view. And moreover, Your Excellencies, if we look to the travaux préparatoires, here there was a proposal by the Netherlands to that very effect, the very same interpretation that the respondent asked the court to adopt today, which is that pursuit had to be commenced from the contiguous zone in respect of a violation within the territorial sea. Yet, Your Excellencies, that proposal by the Netherlands was rejected at the conference, as should the submissions of the respondent on this point.
Sorry, Counsel, you cited a certain professor. Could you repeat the name of that professor?
Professor O'Connell, Madam President.
And are you citing his paper, his book, or what?
Yes, Madam President. We cite his leading text on the law of the sea, and we rely on him as an eminent publicist pursuant to Article 38(1)(d) of this court statute. I'll turn to the second contentious aspect concerning the good reason requirement, and that is whether Amalia's belief reached the threshold of good reason. And the relevant belief here is the belief that Luz and the Daedalus had violated Amalian immigration laws within the contiguous zone, and we accept that the standard of good reason to believe requires more than a mere suspicion, as clarified by the International Tribunal for the Law of the Sea in the MV Saiga case. But, Your Excellencies, of course, it requires less than certainty. And if we look here, Your Excellencies, there are certain facts that assist Amalia in establishing this point. So we know, for example, at clarification 12, that the Amalian authorities knew that the vessel was stolen and they suspected it of human trafficking, which would be a prima facie violation of Amalian immigration laws. And we accept, Your Excellencies, that unfortunately the compromis doesn't disclose exactly on what basis the Mine Coastal Protection Service came to that belief of human trafficking. But there are some facts within the compromis which assist us on this point, some circumstantial evidence that we can rely upon. So we know, for example, Your Excellencies, that following the interaction with the Rosehill, the captain of the Rosehill, and this is at compromis paragraph 42, radioed the Amalian authorities, and here he probably could have described perhaps the navigational movements of the Daedalus, but in our submission he probably couldn't have spoken to the presence or absence of any human trafficking activities on board. Yet we know that subsequent to that, as evidenced in the alert, that Amalia suspected the vessel of human trafficking and it knew that it was stolen, so it has subsequently acquired 2 new facts. And in our submission, this indicates that Amalia has received further information or undertaken further investigation to that effect. And while here, Your Excellencies, I would be speculating, it is a reasonable inference in light of the fact that Luz is a Britannian citizen. He was on board a Britannian vessel, which was first sighted within Britannia's uncontested exclusive economic zone, that perhaps that information came from Britannia in light of the fact that Britannia would be best placed and perhaps uniquely placed to advise Amalia or anyone of the stolen status of the vessel as the flag state. And we know that that fact was accurate because it's an agreed fact between the parties at Compromis paragraph 42. So in conclusion, we know that Amalia has received some information subsequent to the Rosehill collision, and that at least concerning the stolen status of the vessel, that was accurate information. So in our submission, in light of the fact that here there was a vessel that was suspected of human trafficking, it was speeding towards Amalia's coastline with an undetermined number of persons on board, Amalia did have good reason to believe that persons on board the Daedalus hadn't complied with its immigration regulations. I'll turn now to this second substantive issue concerning hot pursuit, and that is whether a radio transmission constitutes a lawful signal to stop. And in our submission, the requirement for the signal is that it be auditory or visual, as set out within Article 23 of the High Seas Convention. Within the plain and ordinary meaning of the word auditory would fall the use of radio in our submission. And this interpretation has been supported by subsequent state practice, where we know that, for example, great maritime powers do rely upon the use of radio within the context of hot pursuit as a means of issuing a signal to stop. For example, pursuits that have been commenced by the United States, by the United Kingdom, by Australia, and by Canada. We do recognise that the International Law Commission had concerns about the use of radio in the 1950s, and we do recognise that it may be put against us that radios should be excluded for that reason. Yet the International Law Commission in the 1950s was concerned about the fact that radio could be open to abuse by states, and that it may not be a particularly reliable means of issuing a signal to stop. Yet, since that point, since the 1950s, radio technology has developed such that it is now a very reliable means of communicating, particularly within a maritime context, and that radio is universally used by vessel operators. Here, we also know that Amalia didn't abuse the use of radio, because here Amalia issued the radio signal over numerous frequencies that are commonly used within the Strait of Malachi, and it issued it in close proximity to the Daedalus. They were within visual range. So in our submission, in light of the state practice which confirms the plain and ordinary meaning of the provision, the use of radio should be considered to be an acceptable signal to stop, and Amalia's pursuit cannot be impugned on that basis. I'll turn, Your Excellencies, to my second substantive submission, and this concerns adjudicative jurisdiction. The starting point here in our submission is the decision of the Permanent Court of International Justice in the Lotus case. And in that case, when it was discussing the exercise of extraterritorial adjudicative jurisdiction, it stated at page 19 that international law, far from laying down a prohibition to the effect that states may not extend the application of their laws to the courts, persons, property, and acts outside their territory, instead it leaves them in this respect a wide measure of discretion, arbitrary rule that can be alleged by Britannia. And I would note on this point, Your Excellencies, that it is not incumbent upon Amalia to show that Britannia doesn't have jurisdiction, and certainly Britannia may have jurisdiction over Luz concurrently. Amalia is only required to show that it has jurisdiction over Luz and that it exercised it lawfully. The relevant potential prohibitory rule that may apply here, or that has been put against us, is contained within Article 11 of the High Seas Convention. Article 11 of the High Seas Convention provides for exclusive flag state jurisdiction over a master or persons in service of the vessel when they're involved in a collision or incident of navigation that entails their penal or disciplinary responsibility. In our submission, Britannia cannot invoke and it cannot rely upon Article 11 of the High Seas Convention because Britannia cannot establish that Luz was the master of the vessel. And while the word master isn't defined in the High Seas Convention, and nor is it defined in the 1982 United Nations Convention on the Law of the Sea. The word master does take a meaning from its context within Article 11, and the context here is at paragraph 2 of that provision. It states that in disciplinary matters, the state which has issued a master's certificate or certificate of competence shall be alone competent to pronounce the withdrawal of such certificate. So the text here contemplates that a master is someone who has obtained such a certification, and yet we have no evidence on the facts before us that that was the case. And certainly we acknowledge that Luz had command, he had control of the vessel, yet that doesn't make him the master in our submission. In fact, the High Seas Convention contemplates that you can have command of a ship but not be the master of the ship. So if we look, for example, to the provisions concerning piracy, where often this concerns persons in command of a vessel when they don't have qualifications and when they have perhaps stolen the vessel, it doesn't describe persons in command of those vessels as masters. It describes them as persons in dominant control of the vessel. So it's perfectly consistent for Luz to be found to be in dominant control of the Daedalus, yet not to be found the master of the vessel for the purposes of Article 11 of the High Seas Convention. And because...
Counsel, sorry to interrupt, but in the view of the applicant then, what do you maintain is Luz's status?
Luz, Madam President, had dominant or effective control of the vessel. He was not the master of the vessel, and if I had to describe him, Madam President, I might describe him as a rogue in control of the vessel.
Very well.
In light of the fact that Britannia cannot invoke exclusive flag state jurisdiction, there is no prohibitory rule on Amalia's exercise of jurisdiction. If in addition to showing Your Excellencies that there is not only no prohibitory rule, but that there is also a permissive basis upon which Amalia can found its jurisdiction, in our submission, Amalia has two permissive bases which it can rely upon. The first of these is flag state jurisdiction over a vessel, and that's contained within Article 6 of the High Seas Convention. Here, the relevant vessel that we're referring to is the Rosiers, which is an Amalian flagged and Amalian registered yacht. And because 117 deaths occurred on board that vessel, in our submission, Amalia could exercise jurisdiction over that ship and over those acts. And we would couple that basis of jurisdiction with passive personality jurisdiction, which would attach to the victim's nationality. In this case, 89 of the victims were Amalian nationals. And the passive personality basis has previously been considered to be somewhat controversial in international law, and yet in our submission it is now an accepted basis in international law upon which states can and do exercise jurisdiction. It has been recognised judicially by judges of this court, for example, in the arrest warrant case, in the separate opinion of His Excellency President Guillaume, the opinion of Justice Rezek, as well as in the separate opinion of Justices Queemans, Bergenthal and Higgins. Your Excellencies, these judicial comments have been substantiated and reflect the practice of states who do extensively rely upon passive personality jurisdiction. So, for example, here we would refer to prosecutions that have occurred within Israel, the United States, Mexico, France, Spain, the Netherlands, and Italy. And while it may be put against us that passive personality jurisdiction only attaches and has only been recognised in respect of particularly serious crimes, the practice of states doesn't reflect that at all. If we looked at the practice of states, it shows that passive personality has been exercised in respect of what might be considered to be common or less serious crimes. So, for example, in the United States decision of United States and Felix Gutierrez, that concerned passive personality jurisdiction being relied upon in respect of kidnapping and murder. But even if we do adopt a higher threshold in order to rely upon passive personality, here, the crimes...
Counsel, excuse the interruption. Isn't there a hierarchy or a priority in theories of jurisdiction? Are you claiming that passive personality, for example, trumps territoriality?
Your Excellency, in our submission, there is no hierarchy, though of course territorial sovereignty and jurisdiction on a territorial basis is particularly important. It hasn't been put against us by the respondent that they assert jurisdiction on that basis. But if we do consider whether there's any hierarchy, Your Excellency, perhaps it is the case that passive personality would be lower in the hierarchy. But as I foreshadowed earlier, it's not necessary for Amalia to show that it has the strongest or the best basis of jurisdiction here, rather than it has a basis of jurisdiction, and that Britannia doesn't have exclusive jurisdiction. So in our submission, even if there was a tension between the relative hierarchy of the claims here, that is certainly not fatal to Amalia's case. In light of time, Your Excellencies, I'll turn to the final issue, which concerns return. And here, even if Amalia has committed an internationally wrongful act, in our submission it doesn't follow that Luz must be returned to Britannia, and that is the case for two reasons. First, if Amalia has prosecuted Luz in excess of jurisdiction, the appropriate remedy there would be the vacation of judgment in respect of the Rosehill collision and a perhaps commensurate reduction in sentence. That doesn't entail return or restitution of Luz. And second, here, it would not be appropriate to require the return of Luz because Britannia has not contested the validity of Amalia's jurisdiction in respect of the Icarus collision, and it wouldn't be appropriate to require his return in circumstances where Amalia has a lawful basis upon which it can detain Luz, which hasn't been challenged by the respondent in this case. Your Excellencies, unless I can be of any further assistance, that concludes submissions for the applicant.
Thank you. Thank you. Please be seated. We will now call upon the agent for the Republic of Britannia. Please, your oral submissions.
Madam President, Your Excellencies, may it please the Court. My name is Kenny Lau, and I appear here today alongside my co-agent, Mr. Nicholas Liu. Together, we act on behalf of the respondent, the Republic of Britannia. I will be speaking, Your Excellencies, for the next 22 minutes, and in this time, I will be making two submissions. First, that Britannia's conduct concerning the Excelsior Island project is consistent with international law. And second, that Britannia is the owner of the sunken artifacts and is entitled to deploy patrol vessels to prohibit Amalia's unlawful salvage. Following these two submissions, my co-agent, Mr. Liu, will then speak for 21 minutes, addressing this court on Amalia's lack of jurisdiction to pursue, arrest, and try Mr. Oscar de Luz for the charges brought against him. We respectfully reserve 2 minutes for Sir rebuttals. I begin, Your Excellencies, with my first submission concerning the Excelsior Island project. Your Excellencies, at the outset, Britannia, we wish to state that Britannia does accept that the dredging operations it had approved had resulted in a landslide, and this has unfortunately led to the Dorian wrasse being declared an endangered species. However, Your Excellencies, this in itself does not suffice to impose liability on Britannia. It is common ground between the parties that Britannia is not under an obligation of result, but one of conduct. And Your Excellencies, Agent for Amalia has submitted that we are subject to two specific obligations of conduct. The first is the duty of due diligence, and the second is the duty to cooperate. We submit that Retainer has not breached either of these obligations, and I will address each in turn, beginning first with the duty of due diligence. Your Excellencies, we do accept that, as stated at paragraph 204 of the Pulp Mills decision, to discharge this duty of due diligence, Retainer must conduct an environmental impact assessment. Also in that decision, at paragraph 205, this court stated that international law does not mandate for the fixed and specific content required of all environmental impact assessment, or EIAs. However, Your Excellencies, this is not to say that there is no minimum content required of an EIA. Judge Bhandari, you earlier queried as to what is this minimum content. And to assist Your Excellency, we submit that this minimum content can be discerned from the very purpose that an EIA is meant to fulfill. And this purpose has been defined in international instruments such as the 1991 Espoo Convention and the International Law Commission draft articles on the prevention of transboundary harm. An EIA is defined as a procedure for a decision maker to evaluate the likely impacts that its activities would have on the environment. Essentially, a decision maker must apprise itself of the risks that its activities would have on the environment, and we do accept this. Agent for Amalia has argued that we have failed to do so because, as stated in paragraph 23 of the compromise, the EIA that was submitted by the private company EIGP did not consider the risks of harm to the marine environment within the Malachi Gap. This is true. However, we submit that Agent for Amalia has conflated the assessment that the private company EIGP conducts and the assessment that Retainer conducts as a state. These are not one and the same things. For Retainer not only had in its possession and consideration EIGP's EIA, but also the ILSA report, which, as stated in paragraph 25 of the compromise, expressly considers the risk of harm to the marine environment and the risk of a landslide occurring within that environment. Now, we acknowledge, Your Excellencies, that at paragraph 25 of the compromise it states that when this report was first provided to the Retainer ambassador, her response was that she would not forward it to the approving agencies. However, we submit that this position was not maintained by Retainer. For as stated in paragraph 26 of the compromise, Retainer subsequently initiated official bilateral negotiations with Amalia. And these negotiations, Your Excellencies, were held for a substantial period of time, no less than a year. It must be the case, given the duration of these negotiations, and given the fact that the content of the ILSA report formed the central basis of Amalia's concern, that the parties would have considered and assessed this report during such negotiations. Therefore, Your Excellencies, we submit that there is no basis for Amalia to now suggest that Retainer had not in fact assessed the risks of harm to the marine environment within the Malachi Gap. With that, Your Excellencies, I now turn to the second obligation of conduct, that of the duty to cooperate.
Before you go to the second point, kindly answer this. You represent a developed country, and there has been admittedly grave loss to the other country applicant because of your landslide. Why should you not pay reasonable compensation and finish off the whole thing?
Your Excellency, we accept that indeed we are a developed country and that the landslide has occurred. However, the obligation under international law is not one of strict liability. This is stated also in the Pulp Mills decision. There must be first a breach of our obligations of conduct. And if this breach had led to the landslide, then Retainer would have to compensate Amalia for the losses. However, here we submit that there had been no such breaches of international law. Turning now to the duty to cooperate. As stated by this court in both the North Sea Continental Shelf case of 1969 and the Gapchikovo-Nagimaros project case of 1997, the duty to cooperate entails negotiations in good faith. We agree with agents for Amelia that this must mean that we have to consider their interests, for this is what negotiations in good faith entails. However, Your Excellencies, we must highlight that Amelia has not shown.
Sorry to interrupt you, but duty also means that you must continuously monitor the whole project which you have undertaken. Admittedly, there is no evidence on record to demonstrate that you have been continuously monitoring your own project and landslide had taken place because of that.
Indeed, Your Excellency, there is a duty of continuous monitoring of a project. This was stated by the separate opinion of Judge Wiramentry in the Gapchikovo-Nagimaros project. However, Your Excellencies, we must highlight that the compromise is silent as to whether or not there was such monitoring, and given that it is the applicant that is asserting a breach, in accordance with the decision of the Mavramatis Jerusalem concession case, it is for the applicant to prove this fact, which it has not done.
Agent, if I may pursue on the line of question of Judge Bhandari, it seems that the knowledge accumulated through scientific sources of what exists underwater should raise the bar a little higher when a developed country undertakes something as maybe unprecedented as what has been done to maintain a higher standard, and if not a higher standard at the initial stages, maybe a standard that moves up gradually as you can determine what the consequences of your conduct are. So could you please address that issue of liability in light of the scientific knowledge that we have on the bottom of the seas?
Indeed, Your Excellency, we do accept that as a developed country, we are subject to a greater standard of care. This was stated by the International Law Commission in its draft articles on the prevention of transboundary harm. And we submit, Your Excellencies, and you have pointed out really the essential question before this court, is that in light of the scientific information that was available to the parties, was Retania entitled to approve these dredging operations? And we submit that Retania was so entitled, and in so doing, it did not fail to give due regard to Amelia's interests. And we say this because, as stated by this court in the 1963 Fisheries Jurisdiction case at paragraph 64, the giving of due regard involves the equitable balancing of the parties' interests. And Your Excellencies, in the draft articles on the prevention of transboundary harm, specifically Article 10, factors have been identified to consider whether such an equitable balance has been struck. The first relevant factor is the likelihood of a certain identified risk materializing, and the second is the importance of the proposed activity to the state of origin, in this case, the dredging operations and the development of Excelsior Island to Retania. I now consider both these factors. First, we submit that the likelihood of the landslide occurring was not a significant one. We first considered the information contained in the ILSA report as stated in paragraph 25 of the compromise. It states that major dredging operations would likely interfere with research and conservation efforts. However, with regard to the landslide, it is only stated as a possibility. And our position in this matter is further supported by this court's decision to reject provisional measures taken up by the applicant as stated in paragraph 27 of the compromise. Now, we acknowledge, Your Excellencies, the threshold for provisional measures is high. It is exceptional in character and should not anticipate a judgment on the merits. However, the standard is that of a significant likelihood of irreparable prejudice to the applicant's rights. This was stated in the land reclamation case in the separate opinion of Judge Court, and a similar standard was applied by this court in the recent 2014 decision concerning Timor-Leste and Australia. Here, given that the ILSA report had already highlighted, and Agent for Amelia has stated this to this court as well, that if a landslide occurs, there would be catastrophic consequences. Surely the only reason why provisional measures was rejected was because it was not likely. And now we consider the importance of the dredging operations to Retania. As stated in paragraph 20 of the compromise, it is to develop Excelsior Island and to produce liquefied natural gas. I quote the 2009 International Environmental Agency report where it states, natural gas will play a central role in meeting the world's energy demands for the next 2.5 decades. And the amount of natural gas that was to be produced is 7 million metric tons. To provide context to this amount, Your Excellencies, this equates to 3% of the world's total production of natural gas in 2012 and 50% of Qatar's total consumption of natural gas in that same year.
Council, are you proposing a new international standard of comparative cost-benefit analysis of what harm a state can do to the environment?
Your Excellency, we are not proposing a new standard under international law. What we are proposing is that we apply the current standards that already exist, which is that of the balancing of the parties' interests. And under the Malachi Gap Treaty, it is the case that Retania does have the sovereign rights to the resources of the seabed. Now, Your Excellencies, we are not seeking to prioritize our interests over theirs. Rather,
So then, Council, what is the relevance of the statistics and the data that you've just cited?
Madam President, we submit that the relevance of these statistics is to show how important this activity is to the state of origin being Retania, which is one of the factors we consider when we balance the parties' interests. And Your Excellencies, we are submitting that
You have undertaken the activity for the benefit of the world or for economic consideration?
Your Excellency, we will not portray Retania as being too altruistic. However, we would say that the production of liquefied natural gas would have benefits to the world as well, as that could cut down on the carbon footprint.
I would like you to concentrate on precautionary principle. What is the present status of the precautionary principle under international law? Can you refer to any recent pronouncement of the International Court of Justice that addresses this issue?
Your Excellency, in the recent 2014 decision considering the whaling case, this court did not state that the precautionary principle was in fact part of international law. However, we do recognize that it is generally accepted that there is a variant of the precautionary principle that is applicable, and this is the one that is stated in Principle 15 of the Rio Declaration, that scientific uncertainty should not be an excuse for inaction. But here, Your Excellencies, we are not relying on scientific uncertainty, and therefore it does not apply to defeat Retania's case. Rather, what we are saying is that Retania was reasonable to believe that both these interests could be accommodated, and we should not now judge Retania's actions with the benefit of hindsight. I now turn, Your Excellency.
Council, excuse me, maybe I'm noting an inconsistency here, and you may enlighten me on it. On the one hand, you're saying that the harmful consequences of the act could not be scientifically predictable. And then on the other hand, you're saying, well, if they do happen, then we're not accountable for it, precisely because they could not be predicted. And then you add to it a sort of a comparative analysis of, but in any event, we're producing something of a tangible benefit. And I sort of see a contradiction between these positions, and maybe you can enlighten us on it.
Indeed, Your Excellency, I will seek to clarify our position. We are not saying that there is any scientific unpredictability here, in the sense that the ILSA report has already stated clearly that indeed, if the landslide occurred, there would be serious consequences. But we are also submitting that based on the contents of the ILSA report, that this is not a likely risk. It is not likely that it would have materialized. Well, it did eventually materialize. We should not be using this against Retania at this point in time with the benefit of hindsight. Now, Your Excellencies, as I see that my time is rapidly diminishing,
Certainly. Please proceed.
I would now turn to my second submission concerning the wreck of the Kargast. I have 2 points to make within this submission. The first is that Retania is the rightful owner of the sunken artifacts, and second, that Amelia's salvage of these artifacts was unlawful. Beginning with the first point, Amelia accepts that the artifacts are of Ruthenian origin. However, it seeks to argue that ownership in these artifacts transferred during 1510, when Baldric Verdigris captured it in the sack of Helios while armed with a letter of marque. However, Your Excellencies, a fundamental assumption has been made by Agent for Amelia that is not borne out on the facts, and that is that there was even a state of war. The issuing of a letter of marque in itself does not say or does not show that there was a state of war between Amelia and Ruthenia. In fact, as stated in paragraph 32 of the compromise, Ruthenian history books describe Baldric Verdigris not as an agent of Amelia, but as a ruthless pirate. But notwithstanding this assumption, Your Excellencies, even if we take the applicant's position at its highest, and that ownership did transfer in 1510, we submit that it is Ruthenia that has ownership today. Judge Bassiouni, you earlier queried as to what is the relevance of the modern law of armed conflict to this dispute. While we are not relying on the modern law of armed conflict, we submit that current international law norms are relevant, and we say this on the basis of the application of the second branch of the intertemporal doctrine of law, as stated in the Island of Palma arbitration case. It provides that when ascertaining the continued existence of ownership rights, we must apply current international law norms. And we submit that international law today provides that cultural property that had been looted must be returned to the state of origin. There is state practice in this regard from as early as 1648. Through the Treaty of Münster and Oliva, Spain and Sweden was made to return looted cultural property to the Netherlands and Poland respectively. The same position was taken at the end of the Napoleonic Wars, the Franco-Prussian War, World War I and World War II. And since 1973, there have been more than 20 General Assembly resolutions calling on states to return such looted cultural property. Now, Your Excellencies, you may have concerns that some states today are still holding on to such looted property, but allow me to address this concern in that in many of these circumstances, there are extenuating facts that places it far removed from our present situation. In many of these cases, the capturing state has been holding on to these looted artifacts for centuries now, preserving it together as a cultural set, placing it on display for public viewing. Here, Your Excellencies, the Ruthenian artifacts has never once touched Amelian soil. It has been lying at the bottom of the seabed for the last 500 years. Therefore, the essential question before this court is this: in such a situation, who should have a better claim to ownership, the looting state or the looted? And we submit that the position under international law cannot be that the thief would have greater claims to ownership than its victim. I now turn quickly to our second point, that Ruthenia's salvage, or rather Amelia's salvage of these artifacts was unlawful. The position under international law is that with regard to sunken state property, it is that state, or rather consent, must be required from that state before intrusive action can be taken against such items. This is the position adopted by major maritime nations such as the United States, the United Kingdom, France, Russia, Spain, Germany, Japan, and these statements were published in the 2004 United States Federal Register. Here, it is evident on the facts that Amelia did not receive or even seek Ruthenia's consent before unilaterally salvaging these items. It had completely disregarded Ruthenia's protests and licensed Mr. Milo Bellezza to take these items without Ruthenia's consent. Therefore, Your Excellencies, to conclude, we do agree with Amelia in one respect, and that is, to be compliant with international law, a state cannot act in complete disregard of another state's interests. Here, only one state has evidenced such disregard, and it is Amelia, not Ruthenia. Unless I may be of further assistance to Your Excellencies, this concludes my submissions, and I will now yield the floor to my co-agent, Mr. Liu.
Thank you, Mr. Lowe.
Oblige Your Excellencies, and may it please the court.
Indeed. Mr. Leo, would you please take the podium?
Madam President, Your Excellencies, May it please the Court. My name is Nicholas Liu, and I too act for the respondent, the Republic of Britannia. I will address Your Excellencies for 20 minutes on the issues surrounding the pursuit, arrest, and trial of one Mr. Oscar Deleuze. And I will submit, first, that Amelia did not have the jurisdiction to pursue and arrest Mr. Deleuze, nor did it have the jurisdiction to try him afterwards. Now, Your Excellencies, Amelia has painted a vivid picture of Mr. Deleuze's various misdeeds, and Britannia has no wish to downplay the tragedy that his recklessness has caused. But it must also point out, Your Excellencies, that this case engages larger issues than the punishment of one man. At its core, this dispute is about respect for sovereign equality, a fundamental principle of international law from which rules of jurisdiction flow. And we submit that no matter how legitimate its concerns, Amelia cannot be allowed to circumvent those rules in order to achieve its ends. Now, turning to my first submission regarding the pursuit and arrest of Mr. Deleuze, we note and we accept that as the applicant has submitted, the most controversial issues before this court regarding hot pursuit commencing within the contiguous zone are the issues concerning the good reason to believe and whether a radio signal counts as an auditory signal within the meaning of the High Seas Convention. And I will turn to each in turn. Your Excellencies, regarding the type of control which a state is allowed within its contiguous zone, we submit that contrary to the applicant's arguments, a state may not pursue and arrest a vessel which has not yet reached its territorial sea. Now, the applicant has argued that if this interpretation were taken, it would mean, I quote, that a state would have to wait for Mr. Deleuze to enter the territorial sea, be suspected of the offence, and exit to the contiguous zone before he could be apprehended. But, Your Excellencies, it should be pointed out that the moment he entered the territorial sea, he would be liable to arrest, because within the territorial sea, a state exercises jurisdiction that is quite akin to its territorial jurisdiction. And moreover, Your Excellencies, even before a vessel reaches the territorial sea, a state is still allowed under Article 24 of the High Seas Convention to take preventive action against that ship. And therefore, Your Excellencies, since a state could still interdict the ship and turn it away with warnings, or if need be, by a reasonable amount of force, this would not leave a coastal state helpless in the face of human trafficking violations. And this is indeed what states do in practice, such as that of Australia in its, at least fairly controversial, policy of turning back the boats. And this demonstrates, Your Excellencies, that the applicant's policy argument cannot be sustained. But more importantly, Your Excellencies, when construing the meaning of a convention, it is accepted as a principle of international law that this court looks to the meaning given to the terms of the treaty at the time, even if a subsequent meaning may be preferable in terms of policy. And Your Excellencies, when we turn to the travaux préparatoires surrounding the passage of this article, we note that the position eventually arrived at by the International Law Commission is the position advanced by the respondent today. Now, the applicant is right that there was a proposal by the Netherlands to broaden this right of hot pursuit within the contiguous zone, but this was at the meeting in 1952. After the meeting in 1956, the position changed, and the final outcome, as summarized by Special Rapporteur Francois, is, I quote, that the offences giving rise to the right of hot pursuit must always have been committed in internal waters or the territorial sea. Acts committed in the contiguous zone cannot confer upon the coastal state a right of hot pursuit. This is written at page 285 of that travaux.
Question. Are the standards or criteria for hot pursuit different depending upon the nature of the hot pursuit, so that if you're pursuing a vessel for a fisheries violation, the standard may be different than if you're pursuing a vessel who has, for example, engaged in theft of nuclear materials? And if so, what more scientific methods than the visualization would you take into account today?
Your Excellency, we would submit that although this court, and to my knowledge, no international tribunal has made a holding on this point, academic authority does indeed support Your Excellency's, not Your Excellency, but academic authority suggests that the answer to Your Excellency's question is that there is a possibility that a more serious offence may justify hot pursuit on a lower threshold of proof. And this is suggested by authors such as Nicholas Poulantzas in his 2002 revised edition of his book on the right of hot pursuit. So we submit that in a case where a person is suspected of stealing nuclear materials, it would be reasonable to act on a lower degree of certainty, although this would still need to meet the standard laid down by the International Tribunal for the Law of the Sea in its 1999 decision in the case of the Saiga No. 2, which, as the applicant has accepted, requires a standard of proof higher than mere suspicion, albeit lower than actual knowledge. And we submit, Your Excellencies, on the facts before the court today, there could not have been more than a mere suspicion that Mr. Luz was human trafficking. And we say this because, as the applicant has acknowledged, all that the message transmitted by the captain of the Rosehill would have contained was in all likelihood that this vessel had caused some sort of accident. Therefore,
Counsel, if I may interrupt, when you're referring to human trafficking, are you referring to it in generic terms, or are you referring to it in terms of the protocol to the Organized Crime Convention, which allows for universal jurisdiction for such a crime?
Your Excellency, we are referring to it in a more generic sense, and this is because the reliance the applicant has placed on this suspected human trafficking has been its import as a potential violation of contiguous zone violations. If they were to rely instead on the definition within the protocol, that would be a different matter, although it should be noted that on the compromis, it is not stated whether either party is a state party to it. But returning to the issue of what Amelia knew when it authorized the pursuit, the applicant has suggested that Amelia must surely have received some further information about Mr. Luz because it then sent out a Coastal Protection Services report stating that he was suspected of human trafficking. But Your Excellencies, this is nowhere stated in the compromis, and therefore Amelia is effectively asking Your Excellencies to draw an inference. And as this court held in the Corfu Channel case, to draw an inference, the circumstantial evidence must leave no reasonable doubt as to the fact to be inferred. And here, Your Excellencies, there are any number of reasons why Amelia might have sent out a note, a message stating that Mr. Luz was suspected of human trafficking. And this could well have been a mere suspicion. It is for the applicant to prove the existence of the facts which it asserts, and it has not done so.
Counsel, when Mr. Luz was detained or arrested, was he in Ruritanian waters?
He was not in Ruritanian territorial waters, Madam President, but he was in Ruritania's exclusive economic zone. However, we do acknowledge that within Ruritania's exclusive economic zone, hot pursuit, if valid, can still be carried out. Our submission is that the hot pursuit was not valid. Now, Your Excellencies, turning to the second limb of the good reason to believe, or rather, my apologies, turning to the signal requirement under the requirements for the right of hot pursuit to be exercised. The applicant has submitted that a radio signal counts as an auditory signal within the plain and ordinary meaning of the words. But Your Excellencies, as defined by dictionaries such as the Oxford English Dictionary, auditory means capable of being heard. And a radio signal is not capable of being heard except under very specific circumstances. First, there must be a radio set on board the ship, it must be working, it must be on, and someone must be listening to it. And Your Excellencies, none of this evidence is present on the facts of the compromis. And moreover, in the event of ambiguity, which is the most that the applicant can say about this provision, Article 32 of the Vienna Convention on the Law of Treaties states that this court, or rather that there should be recourse to preparatory materials. And turning once again to the ILC's commentary on these articles, we see that the ILC, in no uncertain terms, ruled out the use of radio signals as a valid auditory signal, and this the applicant has accepted. Therefore, Your Excellencies, we submit that on multiple grounds, the applicant cannot rely on its right of hot pursuit within the contiguous zone. And I turn now, therefore...
Before you leave this argument, let me ask you a hypothetical question. Maybe on the high seas as a way of exercising their national jurisdiction?
Your Excellency, we submit not. Even in the predecessor to this court's decision in the Lotus case, it was acknowledged that although there may be leeway in exercising prescriptive jurisdiction, enforcement jurisdiction is another matter, which is confined by default to the state's territory. As to which state ought to arrest a ship in such circumstances, we submit that this would be the flag state of the ship, in accordance with Article 6 of the High Seas Convention, which states that a ship shall sail under the flag of one state only, and, save in exceptional circumstances expressly provided in this convention, meaning the High Seas Convention, or in other treaties, it shall be under the exclusive jurisdiction of that state.
Exclusive, or maybe sharing that jurisdiction with a state that has active personality or passive personality?
Your Excellency, we submit that it would be exclusive jurisdiction, and this is in accordance with the plain and ordinary meaning of the provision, which uses the words exclusive jurisdiction. In order to prove that exclusive jurisdiction really meant concurrent jurisdiction, the applicant would have to prove that a special meaning was meant to be accorded to this term, but there's nothing in the travaux that supports such an interpretation. Now, Your Excellencies, turning to my second submission regarding the the trial of Mr. Luz following his arrest, we submit that the applicant's assertions must fail if for no other reason, although I have multiple grounds, than the fact that his arrest was unlawful and that all the proceedings thereafter were therefore tainted. We submit this in accordance with the well-recognized principle that a state must make reparations for a wrongful act. This was held by this court in the Horshaw factory case, and it was stated there that restitution is the primary form of reparation to be made, and this is reflected in Article 35 of the draft articles on state responsibility, which, although they are draft, this court has referred to on numerous previous occasions.
Counsel, are you specifically rejecting the doctrine of malacaptus benedictentus?
We are indeed, Your Excellency. We submit that the doctrine of malacaptus benedictentus, in other words, wrongful arrest is still good detention, if it is to have any effect here, must be to have effect as a sort of lex specialis that derogates from the general principle of making restitution following a wrong. Therefore, Your Excellencies, it is for the applicant to prove that the male captus principle is a rule of custom. But, Your Excellencies, the most that can be said at this point is that there's considerable divergence among states as to whether it is permissible to apply this rule. Although it has been applied in cases such as Alvarez-Machain in the United States and certain older cases, this rule right now is facing a sea change in opinion, as seen in cases such as Ex parte Bennett in the UK and State and Ibrahim in South Africa. Therefore, Your Excellencies, we submit that this cannot constitute the uniform and virtually consistent state practice accompanied with opinio juris necessary for the applicant to prove that this norm is a rule of custom. Now, Your Excellencies, I turn now to the applicant's submissions on the Lotus principle, which it has submitted is still good law. Now, first we note that there have been opinions by this court in the past rejecting this view. In, for instance, the separate opinion of Judges Higgins, Koymans, and Bergenthal, which the applicant has earlier referred to in the arrest warrant case, the learned judges stated that the Lotus principle represented, I quote, a high watermark of this principle in international law, and then went on to consider the various permissive bases of jurisdiction, including universal jurisdiction. and therefore, Your Excellencies, we submit that the Lotus Principle that states may do whatever is not prohibited no longer holds. But in any event, Your Excellencies, even if the Lotus Rule is still good law, we submit that there is here a clear prohibitive principle preventing the applicant from exercising its jurisdiction. Now, the applicant submitted earlier that we were relying only on Article 11 of the High Seas Convention. But to clarify, Your Excellencies, as stated at page 28 of our written submissions, which the applicant has referred to, we relied also on Article 6 of the High Seas Convention, which, as I have earlier submitted, expressly rules out other forms of jurisdiction other than exclusive flag state jurisdiction, unless there is a conventional exception. And since the exceptions which the applicant has relied on are purely customary exceptions, namely the passive personality principle and some form of the objective territorial principle, these cannot permit Amalia to exercise its jurisdiction over Mr. Luz in the circumstances arising before this court. Now, Your Excellencies, if Your Excellencies are not with me on this point, however, I will further submit that even if the applicant can rely on the passive personality principle, the requirements for this principle are not made out. Now, Your Excellencies, it is true that some of the controversy regarding the passive personality principle has died down somewhat. But as Judges Higgins, Koymans, and Bergenthal noted again in that separate opinion, the acceptance of this principle is a principle which is which is limited to certain specific categories of crimes. And turning to other statements of the law, or rather surveys of the law, such as that conducted by the American Law Institute in its Restatement the Third on Foreign Relations, it is stated that this principle is reserved for crimes such as terrorism and attacks on diplomats. And Your Excellencies, although Mr. Luz's crimes, or rather his acts, were indeed irresponsible and did lead to the deaths of many persons, we submit that recklessness cannot be equated to crimes of that level of moral culpability. One cannot be...
Counsel, are you suggesting that the restatement of American law should be binding upon the international community?
Certainly not, Your Excellency. I'm merely relying on that statement as a subsidiary source of law under Article 38, 1D of this court statute, given that the Institute is comprised of eminent jurists from around the world. Furthermore, they reached that conclusion following a survey of state practice, not only by the United States, but also by other countries which have in the past protested against passive personality. Now, Your Excellencies, we submit, therefore, that Mr. Luz's acts, however regrettable, cannot fall within this category. One cannot be an accidental assassin or a blundering bomber. These are all acts which require intent, and intent is the one thing which is missing on the facts of this compromise. Even Amalia has recognized that intent cannot be proven. Implicitly, by charging Mr. Luz with, as stated at clarification 10 to the compromise, crimes including reckless endangerment and negligent operation of a seagoing vessel. And these are offenses which are by definition incompatible with intent. And even their murder charges are based on a definition of murder which includes reckless conduct. Therefore, Your Excellencies, we submit that this ground of jurisdiction cannot be made out. Finally, Your Excellencies, the applicant has submitted that even if its arrest of Mr. Luz was unlawful, even if its trial of Mr. Luz was unlawful, and therefore its conviction was unlawful, it still need not return Mr. Luz to Amalia. Retainia, apologies. And it has submitted this based on a claim that a more appropriate form of reparation would be, well, something short of restitution. But, Your Excellencies, we submit that this is not in accordance with the law of reparations as it stands. Indeed, as I earlier stated, the Horseshoe Factory case established that it is the primary form of reparation. And moreover, in the commentary to the draft articles on state responsibility, it was stated at paragraph 1 at page 96 that in its simplest form, restitution involves such conduct as the release of persons wrongfully seized. And that, Your Excellencies, is exactly what we are humbly requesting that this court order today. Unless I can be of further assistance to Your Excellencies, this concludes my submissions.
Thank you, Mr. Liu. Is the applicant ready to respond? To reply, sorry.
Madam President, Your Excellency, 3 points in this rebuttal. The first is the statement made by the agent for the applicant that Britannia acted with due diligence as to the authorisation of the construction of the island. He made this point on 2 bases. The first is that Britannia was in possession of the International League for Sustainable Aquaculture report, so it must have considered this at some point. Pursuant to the same case that they cited, that is the Nicaragua jurisdiction case, it is for a party who is asserting a fact to prove it, and yet Britannia has absolutely no evidence that they ever considered the International League for Sustainable Aquaculture report. In fact, Britannia doesn't even say that in the compromise. The second basis on which he made this first point is that Britannia's project was important to natural gas supply for the world. Even if this court is willing to take that into account, the Dorian wrasse was critically important to Amalia. This is a fish that the people of Amalia had prized for most of recorded history, and yet Britannia did not take that into account when it was making its decision. Even if the gas is important, so must be the Dorian wrasse. And if the court wants to have regard to the principle of sovereign authority that the second agent for the respondent cited, then it must take into account this interest of Amalia's. Second point of rebuttal is that Amalia is the owner of the artefacts. As to the first limb of Island of Palmas, there was a war in 1510 because, like I said previously, according to Honoré Bonnet, a letter of marque itself constituted a declaration of war. But as to the second basis on which he made this submission, the supposed change in the practice of states, the museums that are holding the Benin bronzes, the Elgin marbles, the bust of Nefertiti, and so on, would be exceptionally surprised to hear that there is now such a norm developing in international law, because in fact the norm is that states that acquired property unlawfully at the time continue to keep it now. The third point of rebuttal is the submission made by the co-agent for the respondent that Britannia has exclusive flag state jurisdiction. And this is critical because unless they have exclusive flag state jurisdiction, Amalia can also have jurisdiction. They made this firstly on the basis of Article 11 of the High Seas Convention, and yet they did not respond to our assertion that Oscar de Luz is not a master, and therefore Article 11 of the High Seas Convention is inapplicable. But second, he claimed that Amalia has exclusive jurisdiction on the basis of Article 6 of the High Seas Convention. And yet that is just another reason why Amalia has jurisdiction. Your Excellencies, may I conclude this sentence?
Yes, just the thought.
That is another reason why Amalia has exclusive jurisdiction, because these deaths occurred on an Amalian cruise ship and they involved the deaths of Amalian nationals.
Thank you. Now, the agent for Britannia, do you have anything in rejoinder?
Your Excellencies, I have 2 points in rebuttal. The first concerning the duty of due diligence, and the second concerning the looting of the artifacts of Britannian origin. Turning to the first point, the applicant has submitted that there is no evidence that Britannia in fact considered the report in the course of the one-year negotiations. However, Your Excellencies, this is an unsustainable claim for 2 reasons. The first is that if Britannia were refusing for a year to consider this report, it would be implausible that Amalia would stay at the negotiating table for this amount of time. And secondly, Your Excellencies, it is an established rule of international law, a rule of custom in fact, that a state is presumed to be negotiating in good faith until this is proven otherwise. This originated in the Mobil oil case heard before the Iran-US Claims Tribunal, and has been supported as well by learned jurists such as Emeritus and Benn in his treatise on general principles applied by this court. Second, turning to the issue of the looting of cultural property, the applicant has submitted that the letter of marque alone constituted a declaration of war against Britannia. Now, Your Excellencies, we acknowledge that the granting of such a letter might well be evidence that there was a state of war between Amalia and someone, but what they must show is that Amalia was in a state of war with Britannia. And on the facts of the compromise, this is pure speculation, and therefore there's no evidence that title properly passed in 1510 in the first place. Unless there can be a further assistance to Your Excellencies, this concludes our rebuttal.
Thank you very much, Mr. Liu. And that brings to the conclusion of the proceedings, the oral arguments of the parties. The court will retire to deliberate and will deliver its verdict shortly. Please be seated. Well, the moment you've all been waiting for is here. The task of the court was twofold. We had to assess the best oralist. We also had to assess the best team that performed. A task, I must say, has not been easy because both teams are extremely good. And very often we were teetering on the edge of doubt, not knowing how to grade the teams because both were very good. Before I announce the results of the best oralist and the best team, I think we will discuss a little bit about the criteria that we took into account. Usually this would never happen in a real International Court of Justice deliberation, which would, as you know, be absolutely in camera. But this is a slightly different proceeding, and so we will disclose the criteria that we took into account. And here I'm going to invite my colleagues to pitch in for the benefit of participants everywhere. We discussed, first of all, we assessed the team's knowledge of the law, but we also assessed the individual person's knowledge of the law. And when assessing the individuals, in order to come up with the best oralist, we forgot about the team support, and we looked at the individual and their advocacy skill, your knowledge of the law, each one of you that appeared before us. We also looked at the knowledge of the facts. We came to the conclusion that, of course, by the time you've made the finals, you know these facts inside out. In fact, you know them so well, you probably believe them. So there, I think we honestly had to concede that both teams were extremely good, and each of you 4 participants was extremely good. We had to take into account, thirdly, the ability to deliver arguments. And, corporately as a team, your ability to deliver arguments, but also individually, your skills in the way, your demeanor, the way you persuade or lack persuasion of the points that you want the judges to believe. We had to assess your ability to answer questions that would perhaps throw you off balance. They weren't intended to trap you, and these were genuine questions coming from the bench. But also there were questions perhaps you might feel that maybe one team was a little bit disadvantaged than the other. They may have, had more questions than the other. Sometimes judges ask questions because of something you might have said that attracted these questions, something controversial you might have said, and that the judges cannot just let go. So you've got to take that also into account. We took that into account to see the individual ability to listen, understand, and to address the question asked. We took that into account. We took into account the demeanor of the participants, each individual participant, as you stood in front of the judges and, in front of the audience, actually the public. We also took into account your ability to manage your time. Whether you found your time inadequate or whether you utilized the time and had so much left over, you didn't know what to do with the time, all that was taken into account. And again, you realize that as a team, time management, affects your performance as a team, but also individually as you're expressing yourself. You need to manage your time properly. So I want to invite my colleagues, in light of the criteria I've just given, maybe to give a comment, a general comment of maybe a word of advice on those criteria I've given, and then we will announce the results. Judge Bassiouni. Judge Bhandari, we'll start with you.
As my colleague has mentioned, the criteria which we had taken into consideration in coming to the conclusion, I must tell you that it has been the most difficult task for all of us to evaluate and judge both the teams. The arguments were of extremely high level. We were very much impressed by both sides, and I would like to congratulate both the teams on this occasion. The one most important aspect which is usually taken into consideration before the domestic courts of the country and even the International Court of Justice, the merits of the case. And that aspect we have not taken into consideration. So merit is the most important criteria for determining the case at all level, except at the moot court level. I can honestly tell you, if the quality of arguments are as good as both sides have advanced today, the task and life of judges would be far better. Thank you.
Professor Bassiouni.
Well, I echo what my distinguished colleagues on the panel said to you, and I knew that they would both cover the most important points that needed to be covered. But I wanted to reminisce with you a little bit about my first exposure to the Jessup, which goes back to 50 years ago, where most of you weren't even born. Having met Judge Jessup and directing in my first year of teaching the team of my own law school, and since then judging them. And I think that you should sort of look at what this Jessup has become. I mean, this is an absolutely extraordinary story, if I can use the term. A story that has brought together young lawyers or young future lawyers from so many countries, 85 countries in the world, 675 teams, and think of the far-reaching effect of both the cross-cultural experience and what this means in terms of future contribution to the rule of law when young jurists like yourselves start to see other young jurists from other countries and other legal systems. I'm a firm believer that the leadership of the world, which is mostly consisting of lawyers, can bring about more peace and prosperity to the world. And as young law students get to know one another in different parts of the world, when their time comes to be the leaders of their own countries, I think that experience can bring an enormous benefit to the future of humankind. And so this is an extraordinary experience of which you are part of it. And when you think that when the Jessup started in the US, we were dealing with 30 law schools, and today we have 500-600 law schools from 80 countries in the world. This is just extraordinary. At the time that I was chairing a commission of inquiry in Iraq, I spoke about the Jessup, and as I was able to reopen 3 law schools in Baghdad, Basra, and in another town, we immediately formed a team of Iraqi law students who participated in Jessup when their country was still recovering from war. And so, I mean, think of all of the implications of that. And the fact that we have teams like yours that have been able to get to the final position in which they are, acquiring so much mastery and knowledge of the law, ability to argue, poison your argument, experiencing sometimes an unsettling question that, you know, for the rest of your life you're going to remember when the painting fell off the podium and somebody is arguing, although he was unflappable, he didn't, nothing, you know, phased him out, even though I'm sure in his own mind he probably thought what was happening here. And so, I mean, these are extraordinary experiences, and I think you should be all very proud. Not only you, but all of those who participated in the organization in ILSE, the supporters of the various law schools, the firm of White and Case, and others who have made this possible. And this is something that will continue to grow. And those of you who have participated in it over the years will continue to make it grow. Now, if I can have a sort of a little anecdote of history, you know the old saying in the practice of law, don't ever ask a question if you don't know the answer. And that's don't ever venture into waters that you don't know really how deep or how difficult they are to navigate. So I'm going to just give you a little vignette of history. Roll the time back, 1815, Congress of Vienna. Very strange experience. They built a special room in the Congress of Vienna, which was a round room, where they had a round table. And the delegates of the 5 countries came in through 5 different doors that opened all at once, so as to represent the equality of the people. Well, at a certain point in the discussion, there were some delegates who said, well, you know, you people from France, and France was then represented by a very famous diplomat by the name of Talleyrand, and said, well, you know, your Napoleon plundered our societies, and he took all of our paintings and things like that. And Talleyrand looked and said, well, what do you want? He said, well, we want this back. And he said, why do you want it back? He said, well, so that we can preserve it for all of humanity. And he said, well, where better can it be preserved for all of humanity than in the Louvre? And so it is that the Louvre today contains so many of the plundered, beautiful works of arts that goes back to the days of Napoleon, including every time I go to France, I see some of the obelisks of my country of origin that I would like to make a claim on behalf of Egypt to have returned. But unfortunately, it doesn't work that way, and international law is still, the law of exceptionalism, the law of the powerful, the law of those who says, well, we can destroy the environment if we can produce a little more oil or natural gas. So, you've got to be careful about the waters you chart when you make these policy arguments, because the world in the global society that we live in is a little bit different than the world of Gentili, Suarez, and others in the 1500s. But you were all absolutely exceptional. This is not an exaggeration, and it was really a very, very difficult judgment. We really had to sort of slice this thing very thin to come up with the decision that we came up with unanimously. Thank you.
Indeed. And so it is the unanimous decision of the bench that the best oralist is Ms. Emily Chalk. Now, regarding the best team, this was an even more difficult decision and a closer call as well between the teams. But our task was to find the team that had the edge over the others. And in determining the team that had a better edge over the other, we took into account especially the ability of the team to rebut or answer the issues raised by the other team in the very short time you were given, and the ability to manage that time in such a way that all the issues raised were addressed, and addressed succinctly, relevantly, and logically, and comprehensively. That was no mean task. We also took into account particularly, because in all the other criteria we could not decide, but in these two criteria we were also unanimous in who the best team was. Of course, we also took into account the time management aspect. And I must say both teams did very well in managing your time. But we think that perhaps one of the teams had a better edge in managing your time better. All the teams were very good with their knowledge of the law, knowledge of the facts, advocacy, etc. And so, it is the unanimous decision of the bench that the best team, and therefore the winner of this World Championship competition, is the applicant team.